Thank you. Let's proceed.
Thank you, Your Honor. Good morning, Your Honors. My name is Mark Zarrow. I represent the plaintiff in this matter. This case is about the dismissal of a complaint on the basis that a complaint that was claiming unpaid wages or back wages on the basis that the controlling and preempting statute is the Massachusetts Wage Act, and that it preempts, according to the hearing judge, the common law claim that this is a contractual arrangement under which the contract statute of limitations, which is Section 2 of Chapter 260, for 6 years would otherwise prevail. The Wage Act is a 3-year statute. Our position, Your Honor, is that when the legislature wants to have a statute preempt the field, when the legislature wants to make that statute the exclusive remedy, it knows how to do so. And in particular, I cite 3 particular statutes: the Workers' Comp Act, the Unlawful Discrimination in Employment Act, and the Mass Tort Claims Act, which all have language which speaks to the exclusivity of that particular statute, that all of the matters that come up related to those particular fields are controlled exclusively by that statute. The Wage Act, on the other hand, does not contain that language, and a claim for wages is really based on a contract. The employee, or in some cases the contractor, is performing services that the other party is willing to pay for. And that has always, as a contract, that has always been governed by the 6-year statute.
I have a question
if you tell me just how this would work in practice. Let's assume you're right. Plaintiff has a claim both under the Wage Act and as a breach of contract by the employer.
Yes.
Under your what you propose, the plaintiff could immediately file suit alleging a breach of contract, and would at the same time then be serving the Attorney General with notice of the intent to file a Wage Act claim.
I believe that could be done, yes.
And then would have to wait 90 days unless the AG gave earlier approval.
Right.
So meanwhile, this other case, the breach of contract case, is proceeding solely on a breach of contract because the plaintiff may not be permitted to bring the Wage Act, and then would have to essentially, when the AG, well, if the AG acted, you would have arguably 2 matters. You'd have a matter brought by the AG and this action.
Yes. Well, I mean, the court would have the discretion to stay the court action pending the results, pending what happens procedurally with the AG's office. I mean, that's one possible solution to having these 2 actions in 2 different forums. But I would emphasize that you file the complaint with the AG, but it's the AG's action. The AG decides whether to proceed and what to do when they proceed, and if they're going to levy a fine or if they're going to get some restitution for the employee. So in some senses, it's a different case altogether. The employee is not represented by the AG, and I think it's not an unworkable situation at all. I think courts can be faced with this many times. If in fact the the plaintiff opts out of the AG system, then they are proceeding under the enhanced remedies provided by the Wage Act, and they have the potential of getting triple damages and attorney's fees if they prevail. So I don't see that as being a bar or a barrier to bringing this. It's in a sense, if you have missed the 3-year statute under the Wage Act, you still have your common law claim to recover money that's owed to you by virtue of this contract. It's either an actual contract or it's a contract implied in law.
But if you're within the 3 years, you would be having the breach of contract claim, and you'd have the Wage Act claim. The breach of contract claim would be against the employer, but arguably against an individual, as here.
Right.
And then
Yes.
you'd have to go through to the breach of contract claim a analysis of the corporate veil.
Yes.
That would otherwise have been made simple under the Wage Act because that person may actually be identified as a person responsible under the Wage Act.
That is true. That's another, I suppose, enhanced provision of the Wage Act. But I don't. That doesn't. Which kind of goes to the second aspect of the case. I don't think that eliminates a piercing of the corporate veil action under the common law claim that the plaintiff has. And I know that the defendant argues otherwise, but that if the Wage Act is not exclusive, then the piercing of the corporate veil aspect of this case would not be excluded by the Wage Act.
Can I just ask a question?
Sure.
I think that there's only one place under Chapter 149, that's in 148B, that has that provision at the end that nothing in this section shall limit the availability of other remedies at law or equity.
I'm sorry, are you asking whether that is in there?
Well, I know it's in there, but it's only in one. Do we read anything given the absence of that provision everywhere else?
Well,
Does it cut against your
I'm
argument?
not sure which section of the statute that's in.
148B?
Okay. Well, that's a different matter. I mean, I know that the defendant relies a lot on claims that were brought under the TIP Act.
Right.
And claims having to do with overtime or things like that. Those aren't common law claims. Those are claims that I don't think there was an action for getting tips or who gets to keep the tip before that kind of legislation came into place. So I'm perfectly content that be exclusively under the purview of the Wage Act. The claim, the basic claim for wages, for payment for services rendered is a basic concept in our law, and it goes hand in hand with the contractual remedies that are available to people. And I would argue that the legislature did not intend to exclude that type of claim. For one thing, if someone brought a claim outside of the 3-year statute and they said they were an independent contractor, and then the employer then started to argue that no, they were an employee, I think you've got a whole other layer of argument that's usually the other way around. Usually the employer says, no, they were an independent contractor. And so there's a whole set of other criteria that have to be involved with something like that.
Before there was a private right of action, which I guess was established just in 1993, correct? I believe this part of the part with the enhanced remedies and the whole procedure of availing yourself of the Attorney General, yes, I believe that's correct. Do we know what happened before 93?
There was I don't know. There's a lot of labor legislation.
No, I'm referring to, there was no private remedy apart from breach of contract, I gather, before 93, correct?
That's my understanding. Yes, Your Honor.
Do we have any case law as to how that case law was interpreted? Do we have any cases that involve breach of contract claims brought by employees against employers?
Yes, Your Honor, I do cite to the Chambers case, which is a case from this court, which says that it's Chambers versus the Shattuck Hospital. Oh, I'm sorry, it's an appeals court case, and basically it says that the wages as incidents of employment is governed by the 6-year statute of limitations. That was decided in 1996, so it was post the 93 legislation. It wasn't argued in that case, so I can't say that it's entirely precedent for this situation, but it certainly upholds the idea that the 6-year statute is involved, that there really was no question that the 6-year statute was involved. So I would argue on that point.
I'm trying to think, why would the legislature in 1993 have wished there to be breach of contract claims when they had provided so comprehensive a remedy, especially one that requires the AG to have an opportunity to bring the claim herself?
Well, I would argue sort of I don't know if it's the adverse of that, but I would argue why wouldn't the legislature want to preserve the common law claim? If they want employees to, get what they have, what their labor has led them to deserve, cutting it off at 3 years is clearly not that. In other words, they give the employee enhanced remedies if they go through this procedure, but do they really mean to say to the employee, you've only got 3 years to do that? And they don't say that in the legislation. And I think it's, given what's involved here and the idea that it's a contract, I think that they would have said that if they had meant that to happen. And they did say that in many other statutory contexts, including discrimination claims, in which I think those were creatures of statute. They came out of legislation, whereas the employment context really doesn't come out of legislation. It came out of the law of contracts. I would also just argue that this court or the appellate courts in this Commonwealth have seen that there is legislation that can exist side by side with common law remedies as well.
Is there any, at least implied, requirement to elect between remedies?
I don't see it, Your Honor, because if you're proceeding in court, I mean there is the idea that the AG can sort of carry this on, and whatever they reach a settlement about, it's your, that's what you have to live with. But if you're going to proceed in court, then you're going to have to prove the same thing.
I suppose in some respects it's almost like Chapter 93A. You can bring a contract
That's
action
right.
and a 93A action. One of them has a 6-year statute of limitation. The other one has a 4-year statute of limitation.
I wish I had thought of that, Your Honor, but that's...
Sure you did.
Well, I'll claim it now, but that's exactly right. You have a contract claim potentially under 93A, and you have unfair and deceptive acts and practices under 93A. And you don't have to elect 93A. You can proceed otherwise. I would also like to address, and I see my time is short, just that under the, in terms of piercing the corporate veil, the argument that I'd just like to push forward is just, without waiving whatever I said in the brief, whatever else I said in the brief, is that if this court does reverse on the statute of limitations issue, then we're essentially starting at the beginning in terms of the complaint proceeding towards trial, and that there's really no reason why there shouldn't be leave to amend the complaint granted to speak in more detail to all of the factors which go into the question of piercing the corporate veil. And as I show in my brief, there were a lot of factors. Perhaps the pleading was less than it should have been in terms of how many of these factors involved. But as the court can see in the appendix from my motion to amend the complaint, that there are an awful lot of factors in that area.
I've got one last question. The Attorney General did proceed in this case, is that right?
That's correct.
And is this part of the record, your client recovered something through that process?
My client did recover something through that process, yes.
Is there any argument made that she having done that it precludes you from bringing a private right of action? Did that ever come up?
I don't exactly read the defendant's case as saying that. They had brought a counterclaim against my client. That is, the defendant brought a counterclaim based on some sort of abuse of process theory, which the judge dismissed on my motion to dismiss.
You mean abuse of process after the Attorney General? Was it
right,
based on that?
That we brought a claim after the Attorney General acted.
Okay.
And our position was, and the judge upheld our position, that the Attorney General didn't act on my client's behalf. They was not my client's lawyer, and my client wasn't bound by that.
But don't we have a rule? I mean, I don't know how hard and fast it is, but don't we have a rule that says, look, if you have a claim against somebody, you've got to bring them all at the same time. So if the Attorney General brings a claim, isn't there an obligation? Why isn't there an obligation on the part of your client to file an action and contract and bring a motion that they be joined?
Didn't go to court.
I'm not sure you could join them. If you're saying that there's the proceeding in the Attorney General's office.
Okay.
Attorney General never went to court.
Never
right?
went to court.
No.
Okay.
Thank you, counsel.
Thank you.
Thank you. May it please the Court, my name is Brandon Moss. I'm here for the defendants, the appellees, the FDR, American Heritage Center, and Joseph J. Plaud. This case turns on exclusivity, whether or not the Wage Act is an exclusive remedy, and bars common law claims for breach of contract and quantum merit arising out of the same fact pattern. Employee performed labor, services, performance completed, and consistent with what this court held in the Massachusetts State Police Officers Association, the Iowa versus Coverall North America case, those are wages. Those are earned, an allegation of earned wages.
What maybe somebody answered this. There's no legislative history about whether this was supposed to occupy the field?
There's a legislative history that I had provided at the end of last week, which...
Oh, I'm sorry. I didn't look
That's
at
no
it. I
problem.
saw it did come in, yeah.
And the executive summary of that legislation is that in 1993, I just very quickly, there was a question about what happened prior to 1993. It's still on the books, Chapter 149, Section 149, which provides that a justice or a clerk of a district court or a trial justice may, upon the application of any employee, issue a summons to an employer to appear and show cause why a warrant should not issue against him for a violation of Section 148. That's the section that dates back to 1886 with wages and has expanded since 1935 to cover all employees.
That's an interesting history. But
Yes.
initially, although we've referred to it in another context as also in essence providing a claim for unpaid wages, this is actually a retention provision, isn't it? I mean, don't hold back too long these individuals' rights to their payments. In fact, it's pretty highly regulated about paying every week or every other week, depending, and making sure that it's not all lumped up so that they drink it away and that they have access to it. So it's primarily about taking care of workers to make sure that they get that money, and that's expanded over the years to go beyond workers. So it's only incidentally about the employer who says, "Oh, I just decided not to pay you at all."
Well, in 1993, there were
Couldn't pay you at all. Go
Well,
ahead.
the concern is about being, whether it's a detention permanently or intermittently, this is a strict liability statute. Conditions, it requires regular,
Right.
frequent intervals of payment. And whether the payment's never made or it's made late, that's a violation of Section 148, the Wage Act.
It just, to your argument that
Yes.
it preempts the whole field of claims that could be brought, maybe you're right, but my question is it really the case when this seems to be about a smaller subset of the larger picture, which is these pieces of it? Pay it rarely, pay it consistently, don't hold on to it too long.
Yes. Well, I think that gets to the issue of recasting it. I mean, the reality here is that he's alleging, the plaintiff here alleges he was an employee, he was a museum director. He alleges he was paid a salary and that he didn't receive the salary. And so the gravamen of that is recasting it as an allegation of earned wages. It's not dealing with other types of issues where, such as a commission or severance pay. It's dealing with the pure and simple issue of, I did work, I wasn't paid for it. And that's what the Wage Act, Section 148, says, earned wages. Those are recoverable, enforceable under that Wage Act. So, and then also I would point out is...
But let me ask you this then. If the contract, I mean, there are a lot of executive directors of lots of entities, nonprofits, and others that have employment contracts that set out a whole array of benefits, paid vacations, stock options, any number of things. I take it that the Wage Act doesn't preempt all of that.
Correct.
So those are contract actions. I didn't get my stock options, or I didn't get opportunities to participate in certain ventures.
It's the Wage Act, although it is the Wage Act, doesn't cover everything that perhaps by common parlance would refer to as a wage, such as, I mean, it does say in the Wage Act that holiday or vacation pay is covered. It does say certain types of commissions are covered. Those aren't issues that we have in this case. It also said...
Well, if mine suggested not only do I get paid days of vacation, but they will pay me to fly to Hong Kong for 3 weeks every year, that would be something. Would that be covered by the Wage Act?
It wouldn't necessarily, because it's a prospective or a future payment. It's a distinction. And some of the cases involving the Wage Act have distinguished between past performance, which is the exclusive basis for the claim here, and future other remedies, perhaps something under a contract. So in a sense, what might be an employment arrangement might actually be split between two different types of claims that are considered Wage Act or earned wages for purposes of the Wage Act and everything else.
So are employment contracts simply no longer contracts?
Well, no, I'd say that in the Malia case that was issued decided by this court last May, the employment contract actually may serve as a basis for determining the amount of damages. It may be a basis for the employee in a private action. It may be the basis for the Attorney General in deciding relief in terms of a criminal or civil citation. But that's, so there is still a benefit with that. But I would say that the Wage Act reflects, as this court held in the Malia case, fundamental public policy. And the 1993 amendment specifically overrode a governor's veto. And Senator Birmingham, in the comments that was submitted at the end of last week, pointed out there was a concern. It was actually taking away, this wasn't something done lightly, and it was done over a governor's veto by
Governor Weld?
The Governor Weld. It was under the veto or overriding a veto because it was a concern that the Department of Labor was not enforcing the Wage Act. In fact, Senator Birmingham said that this was an extraordinary step. These were extraordinary circumstances. That's why the second paragraph was added. I would actually argue that Chapter 149 deals with a number of different types of infractions, but it may be considered perhaps not only by necessary implication, but also explicitly that the Wage Act is an exclusive remedy, because that comment about, from my brother was speaking, Section 148B. Section 148B, subparagraph E, nothing in this section shall limit the availability of other remedies at law or in equity. The legislature did not put that in Section 148. Section 148B is tethered to Section 148 because of the fact that they actually share a common nucleus, which is Section 150, the enforcement mechanism. So the fact that it's in a section that deals with misclassification, and it says that this is not an exclusive remedy, but the Wage Act, Section 148, says it's an exclusive, or it doesn't say that. It's implying language that's in, perhaps it's an argument of implying language in 148B, subparagraph E, into 148 where it doesn't exist.
Let me ask you this question. If you, 148B is what defines an employee, right?
Yes.
So let's say the defense of the employer somebody brings a breach of contract and a Wage Act claim, and the employer says, you're not an employee, you're an independent contractor. So what happens to the exclusivity there? Because your point would be it doesn't cover you at all.
Well, this, in December of last year, this court decided the Crocker versus Townsend Oil case, where an argument was made where the employees were home heating oil delivery drivers. They even went so far as to incorporate businesses dealing with the home.
I know that, but I'm trying to get to the exclusivity because, you can win or lose. But
Right.
if you won on that point, that's your defense. You're not an employee. Wage Act doesn't apply, right?
Correct.
So
Well,
what happens to the exclusivity in that circumstance? Maybe I'm not being clear.
I think you just read the provision that says there isn't any.
yeah, I mean, 148B,
Under 148B, which
stands
is the
alone-
independent contractor
right.
provision,
For
says
purposes of the
you can
independent
do whatever you
contractor
want.
provision, it may be other remedies, but it just doesn't say that in 148, which says that employer has to pay its employee at the regular and frequent intervals depending on the circumstances.
Right, but what if the claim is, well, here, that why is it inconsistent that he can't recover any of the remedies that the Wage Act gives because he wasn't working from 2007 to 2010 but why is that, why would it be so against this that he could recover, if he prevails on the merits, the payments that he was promised that he didn't get before? I guess I just, in other words, the Wage Act has very specific remedies. It's, as you say, strict liability, you get attorney's fees, you get treble damages, you get a whole lot of stuff.
Right.
Okay, you don't get any of that. He can't get any of that. Why is it inconsistent that he should be able to recover on a contract claim what he's owed, if he is owed it?
Because there's a missing person in that equation. Employer, employee, the missing person is the Attorney General. The Wage Act he's required to note for the Wage Act is required to notify the Attorney General. He could go straight to court. He could just wait more than 3 years. The Wage Act statute of limitations has started and ended. It's not a continuing violation statute. The Attorney General is out of it. The Malia case holds that the employee is not acting as a private Attorney General. In that case, the employee actually had argued, I'm a private Attorney General, and that was rejected. There was a concern in footnote 10 of that case. There was a concern in the language of the decision about diminishing the jurisdiction of the Attorney General to allow an employee to more or less decide, when and where and how they're going to bring their claim, cuts the Attorney General out of that picture and diminishes, arguably, her jurisdiction because there's no way of knowing, because there's no forum, minimum or specific forum where the Wage Act is enforced. It could be in small claims, it could be in district court, federal court, or superior court, but it carves out the Attorney General. It renders the requirement of notifying the Attorney General under that second paragraph that was deliberately added. It renders the first sentence of Section 148, of 150, which was changed from Department to Attorney General. It renders all that surplusage or inoperative because it also renders in 1998 where the legislature sought fit to take out the increasing fines and potential imprisonment for violations of the statute because it is a criminal statute, and cross-referencing Section 27C, which is all Attorney General authority, renders all of that inoperative.
Going back to Justice Cordy's question,
Yes.
with regard to exclusivity, you say it's exclusive only as to wages as defined in the Wage Act?
I would argue it's exclusive as to is, at least in this circumstance, alleged earned wages.
So not quantum merit based. Where's a quantum merit claim here that was dismissed?
There was a quantum merit claim that was dismissed, but that claim has two problems. One is that it's recasting the allegation of earned wages because it's all based on performance. There was a time period where there was a dispute about whether the employee was even working because the museum had closed. But the quantum merit was based on that. Plus, there already is an adequate remedy at law, which is an issue with quantum merit. The adequate remedy at law is the Wage Act.
For any quantum merit based claim as well, is what you're saying?
In these circumstances where there's an allegation of earned wages, the argument is yes, that is the Wage Act is an adequate remedy, is adequate as a remedy at law.
So if there were a bonus in this contract, if museum attendance went up 5% a year, you will get a bonus of $1,000 at the end of the year, and if for every 5% you get an additional $1,000, something like that. Is that covered by the Wage Act?
If it's based on the performance, well, I think a bonus perhaps could be considered a commission, and if it's due in, so far as apt and due and determined, it may be considered perhaps a commission.
But it's not always, commissions don't always fall within the statutes, only specified if they're regular, identifiable, or ascertainable, I think it is.
Correct, and that's where it becomes a trickier issue, but this employee is just saying, I worked, and I was entitled to be paid for the period of time I worked until the museum closed.
But in that case, then, the plaintiff would have to bring a breach of contract claim to reserve his or her rights with regard to non-wage
Yes,
claims.
it would be a situation of pleading in the alternative because there is a possibility it might not be a wage. But I would also point out that in terms of notifying the Attorney General, and it leaves it to her discretion as to whether or not to enforce the law, perhaps it may be a parallel track that the employee has notified the Attorney General, has waited the 90 days, or has obtained what's called a right to sue letter to sue before then. But it may be that's the case. It's just a notice requirement, and perhaps if the Attorney General exercises discretion, that might give the employee something. But if there's nothing to require, and that when I say nothing, I mean by way of an exclusive remedy, an employee to notify the Attorney General, it may bypass, it may lead to the concerns with the workers' compensation, a piecemeal system. We could wind up with complaints filed and amended, and with the Iannuccino standard, which has heightened the pleading requirements, you could wind up with, whereas you have automatic liability against the president, treasurer, and controlling officer, you would have to actually prove facts, sufficient facts, which in this case it didn't happen, to assert personal liability against those corporate officers.
Well, Mr. Moss, your time is up.
Thank you, Your Honor.
Thank you.
Thank you.